a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
So much advice to give and so little time, but David Whiting will do his best to get through all of your requests. Our number 1300 222 774. David, good morning.
Good morning, Virginia.
Nice to have you, albeit at a distance. You had some homework from last week and it was about the trickiness of the long-distance relationship when you're trying to get a travel exemption.
Yeah, Patrick from Reservoir has been in a relationship for a period of 4 years with a person in Germany. We didn't get into details as to what the relationship was, but they'd never met. And he wants that person to come to Australia to get a visa. And so my question was to consider how that might be achieved. And the short answer was with incredible difficulty. The federal government is not processing fiancé or prospective spouse visas at the moment, although Patrick didn't indicate he was doing that. And given that the definition of a de facto partner includes people who don't live separately and apart on a permanent basis. So, for example, if a party in a de facto relationship was to go to Antarctica for a season, they would still be considered to be a de facto partner, even though one of them was clearly away for a long time.
Right.
Possibility, register a relationship under the Relationship Act. There's a possibility that would constitute a domestic relationship where one or each of the persons provide personal or financial commitment and support of a domestic nature for the material benefit of the other. They might get that. But if that's not there, even if you could achieve that, you would then have to persuade Border Force that it was appropriate for a visa to be granted. And Border Force has not not a visa to be granted, entry to be allowed. And nobody's been able to find out what the criteria that Border Force applies is.
Right.
Not helpful.
Not helpful. So
No.
You don't like his chances?
No, not on the basis of the conversation that we had. They're processing visas for what you might call immediate family members. Mm-hmm. But if these two people have never met other than online, I wouldn't see that you would succeed in an immediate family member visa.
They may just have to wait until we're through COVID-19. They can actually meet in person and then start to make the argument.
Oh, they can strengthen the relationship over the next period, whatever it happens to be.
Yeah, that's right. Sounds like there's not much choice. So sorry that, Patrick, we could not help you, but let's see if we can help others. 1300 222 774 is our number. Lots of COVID-related questions for you today, David. I'm sure you won't be surprised. Let's hear from Tony in Somerville first up. Good morning, Tony.
Good morning, David and Virginia. My question has nothing to do with COVID. My son-in-law has a business up at Waverley, and the landlord wants to sell the freehold. His is a hairdressing and barber shop, so it's still open and still functioning despite all the downturn. And he wants to put all the advertising hoarding or signs all over the front window of the shop, and the shop sort of is one of those. It's a trendy type of shop that has like an open window, like airy, spacious looking thing. So I'm wondering what he can do. Does he have any recourse?
There will be a provision in the lease allowing the installation of signs, but they've got to be reasonable. And if the landlord's going to sell anyway, so you either negotiate what they're going to be, or you go along and you go to VCAT, and your argument would be that the extent of the signs that the landlord's imposing are an unreasonable restraint on your son-in-law's trade.
Thank you very much.
Pleasure.
Good luck.
Thank you, David. Bye.
Thanks. Glad that we could help. Leanne is in Seaford. Good morning to you, Leanne.
Good morning. How are you?
Good, thanks.
My daughter and her fiancé were buying a home. They were pre-approved for the loan. Then coronavirus hit. My daughter lost her job. Her fiancé's hours were reduced. The developers have decided not to sue them, although they were going to, but they have decided to keep the deposit, which was quite large.
Yes.
I mean, no one could have predicted
a
world pandemic.
When you say large, Was it more than 10% of the price?
Well, it was probably 10%, but that's,
Yes.
it was quite
A
large.
large amount of money, yes.
Yes.
Yep.
I mean, we didn't know there was going to be a pandemic. I can't see how it can be right.
It's possible that your daughter signed a contract that was conditional upon loan approval,
Yep, correct.
and the standard contract says it's conditional upon a loan from X for an amount of Y, and you've got until this long to get the approval.
Yep.
The problem is that you've never seen an unconditional approval from a lender.
Okay.
And the lender's approval essentially says, well, yeah, if nothing changes, we'll lend you the money. Mm-hmm. And in your particular case, your daughter and her partner will have gone unconditional on the contract.
Yes.
So the finance clause no longer applied, and the standard form real estate contract says that the amount of deposit paid up to an amount of 10% can be forfeited to the vendor if the purchaser doesn't settle.
Okay. So that's pretty much it then.
Yes.
Yeah.
That's what the contract will say. If you don't settle
I
for
just
factors
thought
that are
because
not
of
the
COVID.
vendor's problem, then they're the purchaser's problem.
Is there any point, have you had experience, David, of someone going back in, extraordinary circumstances like this and saying, well, no one expected a pandemic, can we talk?
Because it would
Well,
have been fine had it not been for that.
Yeah.
The other problem, though, Virginia, is that it's quite possible that the value of the property's dropped by more than the 10%. So it's because there are provisions that say if the vendor goes and resells, then there might need to be an accounting provided to the purchaser. But if the vendor sells for 90% or less of the sale price, then the vendor's out of pocket as well. So you can go and you might be able to negotiate, but the negotiation I'd be looking at would be seeing whether there's an opportunity of finance from somewhere.
Well, it's too late now. I think it's passed. They extended it a couple of times, but
Well, it's only too late if it's sold.
Okay.
All right.
So
that what I would be looking to see whether there are finance options.
Okay.
Another option would. And this is something you need to think about really, really carefully. Would you be prepared to buy part of the property? See,
I'm not in a position to. Yeah, I
No.
couldn't.
And see, that's the risk, is that whoever buys it has to be able to service the debt.
Yeah, correct. Yeah, I know. That's all right. I just thought with the pandemic, there might be an extraordinary circumstances or something.
I would have hoped so too, I'd have to say. And you know what? I'd give it a go anyway with the conversation, but I'm not a lawyer.
No.
Good luck.
Thank you so much. Bye-bye.
Thanks, Leanne. Patty is in Camberwell. Good morning.
Oh, good morning. Nice to speak with you both. I'm ringing my grandson who's 19. He bought a second-hand car just under 3 weeks ago, and the day my daughter and his father picked the car up, the very next day my daughter thought something was wrong. She was driving it, took it to the garage, big problems, up to $4,000 to fix it. She went to another garage to get a second opinion, same thing.
Patty, did your grandson buy from a dealer? Or
No,
privately?
no. It was a private sale, but the guy that sold it, excuse me, has a company, and his father, my grandson's father, spoke to the wife, and she said, well, we had a roadworthy, which I don't think means a lot anyway, but she said that she'd give him $500. I don't think that's good enough. I mean, he's worked since
Patty,
he was 15.
I'm not sure that that's relevant. We impose obligations on people who sell cars for a living.
Yes.
And so the Australian consumer law would protected your grandson had he bought from a dealer. But because he bought from a private individual, the rules don't apply unless you can prove that to all intents and purposes this person is a dealer. Does your grandson have a copy of the roadworthy?
Yes, yes.
Right,
But with the roadworthy, the engine number on that is different to what is on the car. But I don't know.
Oh, really?
Oh, no, that to me is a beautiful problem to
Oh,
have,
you've got a
Patty.
big problem, right?
You've got a beautiful problem.
Yes,
right?
you've now got fraud.
Yes. Well, you've certainly got a problem that needs explaining.
Yes.
You know, if it's out
Sorry,
by
let
one
me not
digit, it's
assume that,
different.
David. Yes.
Yes, yes. So, Patty, I would be going back and saying, look, you didn't give me a roadworthy for the car.
No, that's right.
And it's possible. Where I would consider tackling this is at the person who gave you the roadworthy. So I'd be going back to the garage that your grandson went to for the first time
Yes.
and say, here's the roadworthy.
Yeah.
Because roadworthies are valid for a period of 30 days, and you would have thought that the problem you're describing might well have developed more than 30 days ago.
Yes, well, certainly the different engine number would have been more than 30 days ago. Can I just quickly ask, though, and this is very nice that you're doing this today, Patty, but you're the second person ringing in today on behalf of a child or a grandchild. That's nice of you doing it. Does your 19-year-old grandson, he's capable of buying a car, but he couldn't call in himself?
Oh, no, he's at work today.
Okay, well, it's very sweet of you to take it on.
Thank you. Thank you. Yes, well, I've been quite upset about it, says my daughter, because, 15 years of age, he started working at Woolworths and then deferred after he's...
Sure.
He's,
no, look, I get that it's hard earned money.
labouring.
Yep, totally.
So-
Well, it's nice of you to take care of him. Thank you. I have to say, this is just my editorial here, David, that I'd like to think that we're growing up kids who can pick up the phone sometimes and look after themselves. Am I allowed to say that, David?
I think you are. I've done it too. Yep.
Anyway, Hans has called in from Geelong. Is it Hans or Hans? Good morning.
Either way.
Good morning.
Good morning, David. There's a property dispute. We bought a property. My wife and I bought into a property about 16 years ago, so the minority owner could stay there with her young children. We went to VCAT, had a determination that it was the minority owner to get a loan and pay us out
Yes.
within 60 days. If that didn't occur, then the property was to be put up for sale by public auction.
Yep.
The minority owner now refuses to sign the sale document. Where do I go next?
You go back to VCAT. There's a process probably in the orders that you've got, Hans. And
No,
what
it
you're
wasn't
asking-
an order. It was a private agreement at VCAT.
All right, so you settled at VCAT, but there were no orders made.
Correct.
Then you're back to VCAT. What I would try and do in a situation like that is get orders that take account of this possibility. So, and one of the orders would be that in the event that a party won't sign a document required, that the registrar at VCAT sign the document for them.
Yes, yes.
So you're back to VCAT.
Okay.
But in addition
not,
to the price,
not the county court.
well, you could go to the county court and force the argument, but at the moment, if disputes between co-owners go to VCAT under the Property Law Act. So I would go there because the matter didn't settle. If the action's been dismissed, then you can't get it reinstated unless it's been left there with a right of reinstatement. So look very carefully at the orders you've got at VCAT.
Okay. All right.
Good luck, Hans.
Okay, thanks very much.
That sounds
Thank you.
sounds like a really tricky one. Mary's in the Dandenong Ranges. Hi, Mary.
Oh, hi, Virginia. How are you?
Good, thanks.
Yeah, look, I've got a query. I live in a very quiet street that overlooks, this property overlooks the forest. And we had a developer moving in as a holiday house, and they removed 78 trees. Then they put dams on the property, and then also hothouses, and they're all environmentally not very sound. So my neighbours and I got a petition to the council. We had 17 people objecting, and there was no permits with the works. Anyway, so what my question is that the council told me that they have the council would come around and tell him to stop working, and then he'd just keep on going as soon as they left. And this happened many times.
Yes.
And I'm just curious now because the council said they're taking this person to court.
Yep.
But then it just dawned on me: do they have the power? Does the council have the powers for them to remove the illegal works?
Yes, they do. The council the council has the power to go to court for an order that it happened. It's there are orders made under the Building Act, and they could be to remove an illegal structure.
Yeah.
So they give them a building notice first. If they don't comply with the building notice, then they go off to court to get an enforcement order.
Do you know for certain that it's an illegal structure?
Yeah, I do.
You do? Okay.
Yeah. Oh, it is, because the council are aware of it.
Okay.
Yeah.
You can also go to council and get copies of any permits that your neighbour has obtained on the property.
Yeah,
And it sounds like none.
I received. What they did was that then they put in a permit after they'd completed the works, but the council haven't approved that though, because none of it meets, fire approval ratings, all of that, environmental.
Yep.
Yeah. Oh, okay. All right. So, but now because of COVID, the courts aren't hearing it. So.
Courts are much slower now.
Yeah.
Yes.
Yeah. Oh, well, that's good. Thank you very much.
Okay. Good luck.
Okay.
Thanks.
Good to know that they actually are, because then you can proceed from a position of strength, some foundation. Hey, David, Patrick from Reservoir has texted in and saying, thank you, David, for your help. This, of course, the homework about the long-distance relationship and trying to get a visa. He's clarified something, David. Just to clarify, my partner and I travel 3 to 4 times per year to see each other. So they have seen each other on many different occasions, and I was hoping to get an exemption to leave Australia. Would that make a difference?
There's only one reported case on somebody applying to leave Australia, and that was somebody who was trying to go to a religious wedding in New Jersey, and they failed.
Hang on, one reported case of someone trying to get a flight out of Australia. More than
yes.
More than one person has flown out of Australia since COVID-19.
Well, no, I understand that. I mean, 2 ministers left last week, but there's a provision that you need a permit from Border Force to leave.
Yes, but more than one permit has been issued from Border Force to leave, because I know of more than one permit.
Oh yeah, no, and as do I. But you need a permit.
Yes.
Right? But there's been only one case where the decision of Border Force has been appealed.
Oh, I see what you mean. Okay.
And in that particular case, the court refused to change the order of Border Force. It requires exceptional circumstances is the requirement.
Yeah.
And if Patrick's proposal was to leave so he could see his partner in Germany, I think the application would fail. If it was an application to go and live in Germany on a permanent basis, it's more likely to be successful.
Okay. All right. Thank you. I just wondered, he wanted to clarify that nature of their relationship. It clearly has more foundation than two people who, have never met. So I think that's a good bit of knowledge to have.
Yes.
All right. Margaret has called in from Fairfield with the eternal challenge of wills. Margaret, good morning.
Good morning. Thank you very much for taking my call. It's on behalf of my daughter, who has a stable, sensible will and simple will, and she wants to now change the beneficiary should all of her family predecease her. Does she need to have the whole will changed, or can she just do it with something simple like a codicil?
She could do it with a codicil. If she wants to get a template from a codicil, you can get one from the lawhandbook.net.au.
Yes.
My preference would be that she simply retype the existing will and make the change. So my preference would be that there be a will rather than her testamentary intentions be in 2 documents. And she just changes the paragraph which says it goes to X and it now goes to Y.
And where does she lodge that will?
She doesn't. Where's her current will?
It's with the solicitor.
You could ask that the will be stored with the same solicitor, or someone could save it on her behalf.
Okay, good.
Your only real worry is that someone will change it in the meantime.
Yes, okay, good. That's not a big worry at the moment. So it's not lodged centrally with the trustees or anything?
Well, there is a register of wills at the probate office, but there are not many there.
Oh, good.
Yes.
Thanks. That's very clear. Thanks for your help.
Thanks, Margaret.
Thanks, Margaret. I hope we're able to help your daughter. I've been given firm eyes through the glass that I'm not allowed, David, to make any comment about someone else calling in for help for their children. I've got those eyes being made at you?
Yes.
Yes, those
I've met
ones.
Katrina. Yep.
Yes, you know Katrina. So I won't say anything there. And I will also read out this text from Paul from Heidelberg, who says maybe his grandmother, this is about the 19-year-old who bought the car, maybe his grandmother took it upon herself to call you up, Virginia. I've noticed that you're a bit of a smart-ass at times, says Paul. A bit of a smart-ass? I have worked long and hard at being a smart-ass, so don't undersell me. Excuse me.
Damned with faint praise.
Exactly. But as I feared, well, look, no, I didn't fear. I knew this had set the hairs running. I put my head into the lion's mouth because I've got lots of texts here on people ringing up on behalf of their children and their grandchildren. David, there are strong views either side. I'll read some in a moment. Keith in Kew, good morning to you.
Good morning, Virginia. Good morning, David.
Go ahead.
Keith.
I'm a lot owner in a owners corporation of 256 lots. And we haven't had an AGM for over 15 months.
It's probably a good thing with 250 lots.
Well, it is and it isn't. I mean, the problem is, I think we're in breach of the Act. The Act says that we've got to have an AGM within 15 months.
Yes.
I'm wondering about the legal consequences of that and whether the current Owners Corporation Committee could be acting ultra vires.
I think the Owners Corporation Committee remains in place until replaced or they resign. So I don't, and it's one of those, we want you to have an annual general meeting so that these issues can be considered, but the world doesn't come to an end if you don't have one. You might talk to the owners, presumably with 250 units, you've got a professional manager.
We do.
Those professional managers are licensed and registered. You might ask them why they're choosing not to hold one. Their answer presumably will be COVID. But they are licensed and registered, so you could turn around and say, well, you're registered, you're licensed. Why would we not complain to the people who license and register you that you're not doing your job properly?
Oh, yes, that'd be good.
So, no, it may not be good. You mightn't, if they get replaced, you mightn't like the replacement any more than these ones. So that you need to work out, there needs to be some discussion as how you could conduct an AGM electronically.
Well, that's right. The Act allows for an electronic meeting to be conducted.
Yes.
So the committee has decided not to do that.
There's also a process in the Act where members can call an annual general meeting.
Requires 25% of the lot owners to back me up.
Yeah, that could be hard because you can't knock on that many doors, can you? Not in this day and age.
It's difficult. Yeah, exactly.
Yes.
You could always
I would be going back to the manager and say you've got some obligations.
All right, well, I can give that a go.
Good luck. Let's see if we can really quickly get an answer for where are we? Here we go. Mark, who is in the basin just before we go to Marcus Padley. Hi, Mark.
Morning. I don't want to get in trouble, but I am ringing up for my son, so I just want to make sure that
We're going to put a black mark against your name, Mark.
I am loving this. This is so hilarious. I've got to read out the comments, but go ahead, Mark.
3 years ago, young bloke bought his first car, same as the other lady, worked hard, paid for it. We got touched up a little bit where we were given a roadworthy, took it to our local mechanics, and he found various things that had added up to about $4,500 to get it to a roadworthy condition. Went back to the bloke I bought it off, who was a private sale. He denied everything, and it went south from there, so I rang Vic Roads for a bit of advice. They were absolutely brilliant. Appointed me an investigator who ended up taking their roadworthy licence off them and being a witness for me when we went to VCAT. Won the case, got the order, no response from the order. I happened to go past not long after the licence was taken off the mob and they'd opened back up.
I'll need you to get to the point quickly just because we're holding people just for you, Mark.
I've been through magistrate's order. I'm now getting told by VCAT that I've got to go through a sheriff's order. Is it worthwhile or do I just give up?
You find out who owns the property and whether there are any assets there that can be seized by a sheriff.
Thanks, mate.
So you do a title search on the property and see if they own it. Work out whether the crowd or organisation you've got the judgment against has any assets.
Beauty.
And remember, you can execute on the judgment for 15 years from the time you got it.
Thanks for your help.
You don't have to be in a hurry.
Good luck with that. I like the idea of getting a sheriff's order. No homework for you, David.
No, got the day off. Yes.
See if you can solve Patrick's problem then.
I'll take it further. All right. Thank you.
Good on you. Nice to chat to you.
Bye.
David Whiting there, your talkback lawyer. Some hilarious comments coming in about what we should do and shouldn't do on behalf of our children and grandchildren and raising independent children. Had a feeling we might kick off that discussion. Important one to have.